Ooh, yeah. Wigmore held it, truth's most powerful art. The finest engine probing every part. An Irish judge call it a weapon bright for those falsely accused to prove they're right.
Welcome to The Law is My Oyster. Today we're talking about cross-examination, one of the most important parts of any trial. Lawyers and judges have long treated it as a key way of getting to the truth. One famous legal writer, Wigmore, called it the greatest legal engine ever invented for the discovery of truth. Irish courts have strongly echoed that view. In one case, a judge described cross-examination as a great weapon someone has when they're falsely accused. In this presentation, I will explain what cross-examination is for, where the right comes from in Irish law, how far it can go and where the limits are, how documents and prior statements are used, and key rules such as the requirement to put your case to a witness. Cross-examination matters because false evidence can arise in many ways. A witness might lie deliberately, but false evidence can also arise through misunderstanding, incomplete knowledge, bias, prejudice, memory failure, or even delusion. Sometimes a witness may not realize their evidence is incorrect. Sometimes a witness may tell the literal truth but leave out the context that changes the meaning entirely. Cross-examination allows the opposing party to test these possibilities. It is also important because a witness called by one side may possess information helpful to the other side, but may not volunteer that information unless it is brought out through questioning. Effective cross-examination depends heavily on having material that can challenge the witness. For this reason, other procedural protections such as disclosure of documents also exist. The right to cross-examine is closely connected with these protections. In Ireland, cross-examination is considered a fundamental procedural right. In criminal trials, this right is linked to the constitutional guarantee of a trial in due course of law under Article 38.1 of the Constitution. The courts have repeatedly stated that an accused person has the right to hear and test the evidence offered by their accuser through examination. Judicial decisions have described cross-examination as an essential ingredient of fair procedures. Taking evidence without giving the accused an opportunity to cross-examine would be contrary to the Constitution. The right also applies in civil cases through Article 40.3 of the Constitution, which protects the personal rights of the citizen and guarantees basic fairness of procedures. The position is reinforced by the European Convention on Human Rights. Article 6.3d provides that an accused person has the right to examine or have examined witnesses against them. In general, any witness who gives evidence can be cross-examined, even if the evidence given is very limited. Cross-examination has two main objectives. First, it allows a party to obtain evidence from the witness that supports their case. Second, it allows the party to challenge the accuracy, reliability, or truthfulness of the evidence given by the witness. A cross-examining party may ask questions about any matter relevant to the issues in the case, even if those matters were not raised in examination in chief. A witness may be questioned about inconsistencies in their evidence, previous statements, their ability to observe events accurately, their memory, and any circumstances that may affect reliability. Cross-examination may also explore matters affecting credibility, such as bias, partiality, and improper motive. Always have a plan when going into a cross-examination. "I'll go at him at 100 miles an hour and we'll see what pops out" is not a plan, it's a Hail Mary. You need to be very clear about what you hope to get out of the witness and how you are going to achieve that. It might be argued that the most important function of cross-examination is that it allows the questioning party to put their opposing version to the witness. If a party intends to challenge the truth of a witness's evidence, that challenge should generally be put to the witness during cross-examination. This ensures that the witness has a fair opportunity to respond or explain. If a party fails to do this, they may be prevented from later arguing that the witness was not telling the truth. This rule promotes fairness to witnesses and helps ensure that the issues in dispute are clearly identified during the trial. While stripping the witness up or extracting admissions is the more glamorous aspect of cross-examination, it is very important to give that witness a chance to respond to an opposing version. This is the meat and potatoes aspect of cross-examination. Try and get these out of the way first. You know that the witness is going to deny the key aspects of your case, so you might as well get it over with. Leave the damaging stuff for later. Let me explain. Draw a line down the center of your page, and on the left-hand side, write down exactly what the witness says during their examination in chief, a verbatim transcript of the witness's words. Don't bother getting the question down, but make sure that you write the answer down in the exact words of the witness. In the right-hand column, make comments and number the comments to correspond with a number you place at the point in the examination in chief that you want to cross-examine. So here, my plan is to get the witness to confirm that he had enough time to prepare for the hearing. This is how to implement that with the information I have. Detail the damage. In other words, make notes of the evidence given in the examination in chief that is damaging to your case. It is a common mistake for a lawyer to cross-examine the witness on evidence that is not damaging at all, or that the opposing lawyer forgot to lead during the examination in chief. Make sure you only cross-examine on evidence in chief that is causing your case damage. Of course, if the witness conveniently forgets some evidence that is damaging to their case, make sure to get that in. For example, you might say, "You never mentioned this in your evidence, but you were given a half day and were paid for a full day, so you could go home to prepare for your hearing." Correct? The key difference between examination in chief and cross-examination is that leading questions are allowed in cross-examination. Leading questions suggest the answer within the question itself. This allows the cross-examining party to test the witness more directly and intensively. Because of this, cross-examination can sometimes be described as detailed, challenging, and occasionally uncomfortable for witnesses. Whilst this is correct legally, on a practical basis, I prefer what is often called the short statement technique. Rather than asking questions as such, it is often a very effective cross-exam technique to put short statements of fact to the witness. These short statements must relate to the elements of your case. This is followed by a short request to confirm the statement that you have put to the witness. So in this example, I want to be sure that the witness confirms that he had an argument with the deceased in a pub on the same day as the murder of the deceased. On the day in question, you were drinking at the Shamrock, correct? Yes. And the deceased was also drinking there, correct? Yes. On your version, you arrived at 6:00 p.m. and left after midnight, correct? Yes. The deceased was drinking with you, correct? Yes. He was sitting next to me at the bar. Witnesses have testified that at around midnight, you and the deceased started screaming obscenities at each other. A glass was smashed, and the deceased left. Yes? Yes. And those same witnesses say that you ran after the deceased. Yes? I didn't run. But you left the pub soon after he did, correct? Yes. This short statement type of cross-examination allows you to keep control of the narrative. You can also control the pace. If you want to get the witness thinking quickly, and so not enable them to doctor their answer in any way, you can increase the speed of your questions. But if you are in the process of severely damaging the witness's testimony, you can slow down to ensure that the jury fully understands what is going on. Another critically important aspect of a good cross-examination is to know when to stop and move on. Once you have obtained the admissions on which to hang your case, move on to the next element of your case. It is very tempting to end with a flourish or go for that extra point. Unfortunately, this is usually in the form of an open-ended question, and that immediately breaks the golden rule. Don't ask a question unless you know the answer already. So going back to that example on the previous slide, Let us say the deceased was stabbed in the pub's car park. If I continued with, "So what did you do outside?" i.e. murder the deceased in the car park, he might answer, "My partner was waiting outside in the car, and she drove me home and we went to bed." Get the factual admission and move on. Don't try and get the opposing witness to argue on your behalf as well. Of course, the defendant's lawyer should get that evidence in with re-examination, but you are not there to do his job for him. Despite its importance, cross-examination is subject to limits. Counsel must conduct cross-examination with courtesy and restraint. They must not ask questions based on facts they know to be false or where they are reckless as to whether the facts are true. Counsel should also avoid making comments during questioning or engaging in unnecessary personal attacks on witnesses. However, it is important to note that a cross-examiner is permitted to put questions based on information that is inadmissible or that he or she is unable to prove, except through cross-examination. This is often a good tactic for placing a thought in the minds of the jury that otherwise would have remained outside the court. One needs to be careful in this context, as a distinction must be drawn between basing your question on inadmissible evidence and a cross-examining party putting questions to a witness in relation to inadmissible evidence, or which would have the effect of eliciting inadmissible evidence. This would clearly be disallowed, and a trial judge should nip such conduct firmly in the bud. The trial judge supervises cross-examination and may disallow questions that are improper, irrelevant, or unfair. Judges may also stop questioning that is repetitive or excessively long once the cross-examining party has had a fair opportunity to ask relevant questions, but judges tend to err on the side of caution. As cross-examination is constitutionally protected, judges should be slow to prevent legitimate questioning unless it is clearly irrelevant or objectionable. Some commentators draw a distinction between cross-examination on the facts and cross-examination as to the credibility of the witness, suggesting that the trial judge would be on more solid ground if they intervened or controlled the latter. Particular care may be required where vulnerable witnesses such as children or persons with intellectual disabilities are being questioned. Judges may occasionally intervene during cross-examination to clarify evidence or ensure a witness understands a question. However, excessive judicial interruption can undermine cross-examination. If a judge intervenes too frequently or appears to favor one side, this may create an impression of bias and can lead to a verdict being challenged. At the same time, a failure by a judge to intervene when a witness refuses to answer questions may also undermine the fairness of a trial. Finally, a judge should be slow to criticize the overall performance of a witness under cross-examination, as this may be seen by the jury as an invitation to disbelieve that witness. The jury must be left to form their own opinion on the credibility and demeanor of the witness. One of the most powerful tools in cross-examination is the use of previous inconsistent statements. If a witness has previously made a statement that conflicts with their testimony in court, this may be used to challenge their credibility. The procedure for doing so is governed by the Criminal Procedure Act, 1865. If the witness admits making the earlier statement, no further proof is required. If the witness denies or does not admit it, the earlier statement may be proved in evidence. Normally, such statements affect credibility rather than proving the truth of the facts stated, although legislation provides limited exceptions. If an accused person chooses to give evidence, they may be cross-examined by the prosecution and by any co-accused. By choosing to testify, the defendant in the criminal trial is essentially foregoing his right to silence and his right against self-incrimination, which means he or she cannot refuse to be cross-examined. If a defendant does not want to be cross-examined, then he or she should exercise their right of silence and not testify at all. Cross-examination is central to the fairness and effectiveness of the trial process. It allows evidence to be tested, credibility to be examined, and the truth to emerge through careful questioning. At the same time, it operates within a framework of rules designed to protect fairness for both parties and for witnesses. Understanding these principles is essential for appreciating how the legal system evaluates evidence and reaches decisions in contested cases. This has been The Law is My Oyster with Declan Olula. Take care and seize the day.